Good afternoon, everybody. I'm attorney Marjorie Brunelli, and today I'm just going to address a question as to attorney's fees specific to family law. I think last week alone, I probably got the same question 5 or 6 times from different people. So I decided to record a quick video just to explain the differences so I don't keep repeating myself like a broken record. You know, if somebody calls and asks this question, I can simply refer them to either Instagram or Facebook. But anyways, so the question is, what's the difference of attorney's fees and costs when I have an amicable, uncontested divorce or a contested litigated divorce? So generally, for an amicable divorce, where the parties are in agreement with everything, it's a flat fee. So let's suppose, for the sake of just an example, you call me and you say, okay, we're in agreement with everything, we don't have minor children, we have a few things we need to divide as to assets and liabilities, but we're in agreement. So how much will that be? So just for example purposes, let's say it's a flat fee of $2,000. Again, I'm not saying that this is what I charge, I'm just giving an example. So I'm just throwing a number out there. So that flat fee is going to cover everything: preparation of all the documents, attendance at the final hearing. The only thing that fee does not cover is third-party costs. That includes court costs for the filing of the petition and the action, the dissolution of marriage, the action for the dissolution of marriage, or, for example, costs with process server. So those are just a few examples. Those costs, anything that's not relating to me, is the obligation of the client. So that is separate and has nothing to do with me. Generally speaking, filing fees and process server runs around the $450, $500, depending on where the party is located and how easy it is to find the person, the other side, that you're going to serve with the summons and the petition. So it's pretty straightforward. You sign the retainer agreement, you pay the flat fee, and we prepare all the documents, submit it to the court, schedule the hearing, and attend the hearing. Now, if the case is litigated, that's a totally different story. So that's where it gets complicated, and sometimes people don't understand. So if the case is litigated, it's much more complicated. So you're still going to sign a retainer agreement, but it's no longer a flat fee. The costs are still the responsibility of the client. So anything involving a third party, court costs, process server, mediator, expert witness, forensic accountant, psychologist, therapist, guardian ad litem, and I can go on and on and on. Those are just examples. Those costs are the responsibility of the client. So that is not included in the attorney's fees that the client is going to be paying. So how does that work? In a litigated case, generally, and it's going to depend on the experience of the attorney, the size of the firm. So each attorney is different. Generally, for litigated cases, I require a deposit between 10 and 15 hours. And obviously, the attorney hourly rate is going to depend on experience, location, size of the firm, so on and so forth. I've seen attorney's fees between $250 an hour up to $650 an hour. And I'm sure the fancy firms, you know, that work for the rich and famous, they're probably charging the thousands by the hour. So it all depends, obviously. So again, for details on that, each case is different. You know, give me a call, we'll discuss it, I'll explain everything to you. But I would recommend a consultation, a 1-hour consultation, because it's very hard to explain the whole process of a contested divorce in a 10 to 15 minute phone call. So really, I recommend a full hour consultation for those particular cases. So in those cases, the way it works is you sign the retainer agreement, then you make the deposit between 10 to 15 hours. I generally require 15-hour deposit just because there is a ridiculous amount of documents that we need to prepare. And if we're the ones filing, we have to prepare the petition, all the documents that go with that, a bunch of affidavits, financial affidavit, Then shortly after, we have to do mandatory disclosure, which there's a checklist. It's a huge list of documents that need to be provided by both parties. And all of that is very time consuming. We have to review all of the documents, redact all private information. It takes hours to go through all of that. And once we receive the documents from the other side, we got to go through everything as well. So it's very complicated, and I think sometimes people don't realize how much time we're actually expending in doing all of that. So it does take a lot of work and a lot of hours. And litigated cases can last for months on end, sometimes up to a year, sometimes even a few years. So it's hard to, sometimes, and I understand that, sometimes the person wants to know, how much am I going to spend? I can't tell you. I wish I had a crystal ball so I could tell you this is how many hours it's going to take, but I don't know. There's no way of telling. The way that it works, it also depends on the other side, and it depends on how the judge is going to rule. So it's a combination of factors, and it's very hard for an attorney to predict how many hours it's going to take to resolve a certain case, particularly if it's litigated. So you make the deposit, and once the hours are expended, you have to make another deposit to continue your representation. And that also is going to depend on the attorney or the firm. Some attorneys require the same amount of the deposit as the initial deposit, or a lesser amount, as long as you keep making that payment every month. Once you receive an invoice, the representation will continue. Obviously, if you stop paying your attorney's fees, it's very likely that the attorney will withdraw from your case and you're going to be without representation. So those are the differences. I just wanted to come on here and explain it quickly, because it seems that there's a confusion for some reason on how that works. And I think it's because sometimes people think that their divorce is going to be amicable, and then within a month of signing the contract, paying the flat fee, they realize, okay, we're actually not in agreement, and now this is a litigated case. So it's the same situation. You pay the flat fee, it becomes litigated, you're going to have to pay the difference of the retainer that's going to be now on an hourly basis. So my retainer agreement contains language explaining that, in case that happens, because that happens a lot. People think that it's going to be amicable, and then all of a sudden they are fighting over everything. So I just wanted to clarify. And again, if you have any questions, or if you want to schedule a consultation, feel free to give me a call. All my information is up in the bio. And I hope you all have a great week. I'll talk to you soon.